What's up? What's up? Can you hear me? How does it sound? Sounds great. Good. I'm about to talk about the Declaration of Independence. I'm about to go on TikTok and then post it. All right. There we go. I actually like that. There we go. How do we look? All right. I like that. Oh, crap. I forgot to share it. All right. Let me find the two things that I'm missing, pull them up on Patreon, then we'll be good to go. What do I need? I need now I don't remember. Let's see. What do I need? What will happen here? What happened there? 1774. Okay. What's up, everybody? Let's see here. Let's see. It's never when you need it. You never find it when you need it. Let's see. Let me see here. I said this, the Supreme Court. There's so much. Let me see. That's not it. I'm looking. Actually, that is right. Okay. I need to find the 1774. What was it talking about? 1774. They were going in 1774. They were going over the first Bill of Rights. Let me see. Dang it. Maybe it's in the common law. Jurisprudence, warranted by what authority? Impartial decision maker. Real American history. Boom. Got it. All right. I'm ready. I mean, ain't nobody here, but. All right. So that will be. All right. What's up, everybody? Not YouTube, TikTok. There's nobody on TikTok, but I need somebody to let me know how it sounds. I'm sure it sounds fine. If my Bluetooth is even on. Yep. Cool. What's up, everybody? What's up? How does it sound? Sounds great. All right. Maybe more people will join in. And let me make sure I'm set up right. So I got that. And then we need a nice cold one. It is water. I have to say that, otherwise they'll try to flag it for something. You guys are free to share this live stream to anybody. All right. Over the past couple, I gotta record my actual camera because I'm gonna clip it and make it let's see here. Boom. All right, I got my real camera going. Perfect. Make sure my light is good. Give me a little more light on the camera. I have 3 cameras going. This is hilarious. I have one for TikTok, I have one for YouTube, and I have one that will be re-uploaded on YouTube. So what I'm going to go over real quick, because I didn't do it last time. Well, I did do it last time. This is what we've been going over, is ultimately English history and the common law of England. And so we're going to go over just to reiterate a timeline so that when we get to 1607, there's no mistaking. The words are backwards on the board. That's great. Let me flip that around. Boom. There we go. Perfect. All right. So there's no mistaking. So we have a right timeline of how we got to 1607. So I'm going to go over that real quick, and then I will begin this timeline. Hopefully it won't take too long. I'm anticipating 2 hours so that I can tell myself that in the camera when I start editing it. All right. So this is essentially a history or an overview of the common law of England, the Supreme Court of Tennessee, and the Supreme Court of Florida has said that the common law has come to us by way of the scriptures. Okay. So we have the Bible as the pinnacle of the timeline, and you can do with that information whatever you want to, but primarily the Old Testament. Because next thing on the timeline is 510 BC, where let me see, it said unstable. Okay. Where you see a guy named Dunwallo Momushus. He is establishing what they call the Mamertine laws, and the Mamertine laws, his son entitled the common law, or at that time in ancient England, it would have been called folk law or folklore. I think that was how they said it back in the day, but it doesn't matter. That was the first time the phrase common law was used. After that, you have 490 years to the birth of Christ. Then you have the resurrection of Christ. And then you go from 100 to 200 AD in ancient England with these people called the Druids. The Druids committed what they considered their laws to memory, and that would have been the start of what they call the unwritten law or the common law. And actually, fun fact, I learned today a guy named Alfred the Great had, I forgot what part of the time period he's in, but Alfred the Great compiled the laws of England of his time as well. And it's called the Doom Book or the Doom Beck because it's ancient England. When I say ancient England, I mean before William the Conqueror, and I'll kind of allude to that. And Alfred the Great cited what they called the Decalogue. The Decalogue is the Ten Commandments or the explanation of the Ten Commandments. I've been telling y'all for over a month now, I've been studying Deuteronomy, and Deuteronomy is the explanation of the Ten Commandments. So it is the story of how people obeyed and disobeyed God. But more than that, it is an explanation of the Ten Commandments. That word Deuteronomy means second law. And that second law was considered the constitution of the Hebrew people or the people of God. And in ancient England, this guy named King Alfred the Great of England at the time, when he compiled the laws, it was just a short list, and then it was after that short list was an explanation of the Ten Commandments as the laws of England. Okay, so that is from 100 to 200. You got the Druids from the 300s as far as influence. From the 300s to the 1200s AD, after the resurrection of Christ, you have the Angles and the Saxons, what we now call the Anglo-Saxons. You have the Angles and the Saxons as predominantly dominating what we now know to be the common law of England, right? Now, before the 1200s, you have the year 1042 with a guy named Edward the Confessor. Edward the Confessor was the last Saxon king of ancient England. And he would have been known for compiling all the legal principles up until that time in his lifetime. And then in 1050 AD, you get a trial by jury. That's one of the first rumblings of a trial by jury. And they say they attributed that to the 12 apostles. Okay. Boom. So that I've said this video is already on YouTube, but this is an explanation of the common law of England. The common law of England is defined as the ancient unwritten laws of England. And that would have been this time period from as old as the Bible, from 510 BC up until, we'll say, 1066. Everything after 1066 changes with William the Conqueror. William the Conqueror, or what they call the Norman Conquest, is a total, what they call a regime change in England, right? So when we talk about the common law, we're supposed to be researching and learning the principles from 510 BC to 1066. And because after 1066, you have William the Conqueror. This dude's from Normandy, and he is under the influence and control of the Roman Catholic Church, right? Via French influence, or by way of French influence. And so 1066, you have William the Conqueror or the Norman Conquest. And then the 1100s, you have King Henry I, which is who establishes the writ system in England. You have 1215, where you have the Magna Carta, which is another culmination of English principles, but now recognized to what they now know to be the Normandy people. I even dare not call them English, because they changed to William the Conqueror changed the language of the court system in 1066. So they used to speak a language called Anglo-Saxon English, but now they speak we speak a Normandy French type of English, and that I'm gonna make a whole video on that one day. And so the 1100s, King Henry II established a writ system. So that's where we get, you may not know common law writs, but they got a mandamus, they got a quoto, warranto, all of these things that can be used to assert common law rights and privileges inside of a commercial court. Okay. Then you have the Magna Carta in 1215. Then from the 1300s to the 1500s, they really establish a case law system, what they call a court reporter, where they're compiling all the cases that went down during this time period. Then in the 1600s, which we will restart here, but in the 1600s, you have a major influence called Edward Cook. Edward Cook compiled the laws again of England, modernized them into the English we know today, or you know what I mean. And so that would have been called Edward Cook's Institutes on the Laws of England, and that's in the 1600s. And then in the 1700s, you have William Blackstone's Commentaries on the Laws of England. They would have started being published in 1765. And then that would have been, to us, to what we now know to be Americans, a culmination of English law and how the law works globally, and then how it primarily worked in England. So that would have been William Blackstone's Commentaries on the Laws of England. Before that, you have Edward Cook, is spelled Coke, C-O-K-E, Institutes on the Laws of England. Okay, so that's just a little recap, a little review. Now we're going to talk about the Declaration of Independence and the timeline leading up to the Declaration of Independence, and then what is the Declaration of Independence and what is it about? Because I'm under the impression that we have no clue what it's about, and I think these timelines help give us a great picture on how to view the Declaration of Independence. And also, I don't think I'm special at all, but I've heard nobody explain these things. So I say this all the time. If you're learning this from me, we are all in trouble because I am a nobody. Right? So if you're learning about the Declaration of Independence from me, yeah, we're cooked. We're cooked, chat. We're cooked. Right? This is not my job. I do not get paid to do this, and y'all don't pay me to do this. All right. You guys can share this, by the way. That will help me. All right. 1607. There is a great song. I sing it every time. I don't sing it. I watch it. Okay. Pocahontas. Y'all remember Disney Pocahontas? The beginning of the movie. They sing a song that says in 1607, they sailed the ocean sea for glory, God, and gold in the Virginia Company. Y'all remember that? All right. So what happened in 1607? Them boys showed up from England. They set up what we now know to be corporations, right? Colonizing, right? Okay. So in 1607, I forgot about this, but this is under the reign of King James. I learned this right before I started this live. He was called King James II and King James IV. So you can go do your homework on that. I don't know how that works, but apparently he was King James IV over Scotland, but only King James II over England. So I don't know how that works. So you got King James the fourth. And the reason I say the fourth is because when I read Supreme Court cases, specifically, I remember Missouri, the Supreme Court of Missouri said that they adopted the common law of England as it existed at the time of King James IV, which is the year 1607. So that's the only reason I even remember that. But I think that's very important to note. All right. So what happens in 1607? They show up from England to North America and plant a colony called the Virginia Company. And I want to be very clear. They considered this two different things. And I'm not going to go into that today. We're just doing a little timeline, a little overview, but they, and I got law books that say this. They said there was a difference between the Virginia Company from a Virginia corporation charter and then the Virginia colony from the people. Okay. But when you really study the timeline, they'll say, okay, well, the common law got established in 1607 in England and from England to Virginia. But when you really study 1607, they don't have no common law here. They may say that just to kind of memorialize it, but them boys were struggling to survive in 1607. They said they had one job, and that was to learn how to survive because they were not. I'm not being racist. I'm just saying they were not from here. So they didn't know the land. They got diseases immediately. They actually, I think they left and had to come back in like 1613 or something like that. So yeah, these boys weren't just coming here and then boom, nothing, everything just went smoothly. Their first objective was to learn to survive. And the more you study that, they actually had to fight to get the common law of England in Virginia. And so they don't really get the common law of England until like the 1630s. So that's very important. So when they're citing, like for instance, the Supreme Court of Missouri will say, okay, well, the Missouri adopted the common law of England as it was under King James the Fourth in 1607. Well, they're not talking about Virginia. They're talking about in England because in 1607 they didn't have no common law of England. It was it wasn't but 100 of them. So and they didn't make it then. They had to come back. They had to send another voyage out in like 1613. So very important. Okay, so we know what happens in 1607. The colonies, Virginia shows up, and then they start, figuring that out and expanding, creating different colonies, and then people start migrating, right? In England in 1714, now there are other people in between King George the First and King James the Fourth, or King James the Fourth. So that's not important to me. I didn't see anything major in that time period. But what I want to highlight is between 1714 and through the 1700s, King George the First, King George the Second, because we're leading up to this Declaration of Independence, right? Okay, King George the First is not from England. He's the King of England. He's not from England. He doesn't speak English. King George the First and King George the Second are from Germany. This is very important. King George the First is the King of England. He never touches England. He never goes to England. He doesn't speak English. He doesn't give two craps about England. Okay, does this make sense? Anybody getting this? Okay, King George I does not care about England. I don't even think he went. He is from Germany. The only reason he's the King of England during this time period is because of the bloodline, not because of nationality. Does that make sense? The same is true for King George II. King George II was not born in England, but he's the King of England by bloodline. And last time I talked about this timeline, we told you that William the Conqueror was a regime change. And so all of these kings are successors, not of the ancient Anglo-Saxons where we would attribute the common law principles from, but these guys come from the bloodline of William the Conqueror, who is Norman French. Okay. So King George I speaks no English. He speaks complete German, doesn't care about England, anything. King George II, born in Germany, speaks no English until he's about 40. Does not care about England. Okay. During these time periods, let me see. No, that's not what I need. Anybody getting anything out of this? That's not, there we go. During this time period, between, that says 1727 till, no, from 1714 until 1760, because King George I and II don't care about England, they gave legislative sovereignty to Parliament. So there would be a period as a king where what you said became law. But because these two kings don't care about England, they gave legislative sovereignty to Parliament. Parliament is the legislative branch. That would just a mirror. We have Congress, which is which is the federal legislative branch. Your state has a legislative branch. They write statutes. Okay, well, King George I and King George II give legislative sovereignty over to Parliament. So that means Parliament can write whatever they want and call it law. Because remember, this is a monarchy, right? And actually, I wonder if I can pull it up that fast. Let's see, common law. Oh, yep, perfect. So 1714 to 1760, you got King George I, King George II. They're kings of England, but they're not English. And they want to make that very clear. They don't care nothing about England. So they speak German. King George II spoke German until he was about 40. Then he learned English. And I think King George II did eventually start going to England. I think he had to at one point. It was like, all right, I'll go. And so because they didn't care about England, they gave legislative sovereignty over to Parliament. So Parliament was in England just writing whatever they wanted. They say, yep, you owe us. We're going to write all these. Yeah, we don't care nothing about the common law of England. We don't do that here, sweetie. You know how many times you done heard that in your life? Oh, yeah, we don't do common law no more. Right? So I want to make a distinction. The Supreme Court of Wisconsin said in the 1900s that due process of law here. Due process of law is a principle from the Magna Carta in the 1215. Okay, so that is where we call due process of law would mean what it meant in ancient England before William the Conqueror, right? So Wisconsin's law is the common law of England. So Wisconsin says that due process of law does not mean the will of the legislator. It means according to the law of the land, including the Constitution with its guarantees and the legislative and act. That's not what I'm supposed to be reading. That's not what I wanted. I'm like, it sounds real good, but that ain't what I'm talking about. But it is true as well. Due process of law does not mean the will of the legislator. Here in England, it means the will of the legislator. It means whatever they want it to mean. It means according to the law of land, including the Constitution, guarantee, legislature. Okay, no, that's not what I was looking for. I wonder where it's at. I really want to read it. Sorry. It's very good. Very good. I wonder if it's New York or Minnesota. It's a state Supreme Court. Let's go to New York. And then let's go to Minnesota. I don't have a Minnesota. I have Minnesota, but I don't have a tab for it. Yes. Perfect. Got it. All right. Supreme Court of New York said, although it be true that in England, Parliament is omnipotent. What does that mean? They're all powerful. Who is Parliament? Parliament is the guy who writes the guys who write statutes, codes, regulations, ordinances. Okay. So they say, hey, it is true that in England, Parliament is omnipotent. What does that mean? That means King George the First and King George the Second gave legislative sovereignty over to Parliament, the guys who write the statutes and the codes for England, right? And so they said, the Supreme Court of New York said in the mid 1800s that that it is true that in England, Parliament is omnipotent, but that principle does not prevail with us. They said here, the sovereign and absolute power resides in the people, right? So what does that mean? I mean, they can't write whatever and it magically can take away your right. They can do that in England. We not with them no more, right? They can do that in London and the United Kingdom because they are under a monarchy, a supposed monarchy, and under this lineage of their monarchy, King George the First, King George the Second, who didn't care about England, barely spoke English or didn't speak it at all, say, "Hey, yeah, y'all write for them and do what you need to do. We don't care," right? So problem number one. And I know I'm saying the same thing over and over, but we got to get this. King George II, King George I, not from England. They were born in Germany. They're only the King of England by blood. They did not care about England. And as a result, they gave legislative sovereignty over to Parliament in England. Okay. Now, why is this significant? Because I have a book here. This is my book for those who have it already, The Discernment of the Vigil. It says, I cite a law book from the 1750s, which I learned today that book actually came out in the 1730s. That these people called Jesuits, born in the king's dominion, ordained under the pretended jurisdiction of Rome and under a pretended act of parliament. What did these Jesuits do? Well, they took over the sovereignty of parliament. And instead of writing things that were according to the course of common law, they wrote things according to the course of civil law. And as a result, they started writing statutes, codes, regulations, and ordinances that took away the rights of the English people. And it is in this time period where you will get the rumblings of why they fought the Revolutionary War. Does that make sense? Does that sound like, oh, they're kind of painting a picture for me, right? So they say King George the First, King George the Second, not born in England. It was almost like they were waiting on the perfect opportunity to strike. And they said, oh, these boys don't like England? Perfect. Let me get up in there. You know what I mean? So they said, oh, yeah, we're in there. Yeah. So they probably went to these dudes and was like, oh, yeah, we don't like, yeah, you don't need to be worried about little old England. You stay in Germany and don't worry about it. Let us take care of it. And we'll be writing things on your behalf. Okay. So they took over the legislative power of England during this time period. Okay. Good. I think I've stressed that enough, right? I keep reiterating because this is the part we never hear. I've never heard about this. Never. I learned this on accident. I said, they didn't speak English. I was listening to somebody talk and they were like, oh yeah, King George the First wasn't born in England. I was like, what do you mean he wasn't born in England? They said, yeah, he was born in Germany and he spoke German. He was never in England. They didn't care nothing about England. Like, what do you mean they didn't care nothing about England? They're like, they're only king of England by bloodline. They would look over if y'all hear stuff that they're finna start shooting, I live in the hood. I just want to let y'all know that. So there's fireworks, but there will be gunshots real soon. uh, but King George the First, these jokers didn't care nothing about England, and so the enemy waited for the perfect time to strike. And then you get these books I'm getting, and I'm like, oh yeah, these people called the Jesuits showed up out of nowhere under no actual authority of law, and they started writing rules, regulations, codes, and ordinances. I'm like, oh, well, that makes sense, right? So they said they did this during the 17, at least in the 1730s. Who knows when they got there? I don't know. But these people called the Jesuits, born in the King's Dominion, ordained by the pretended jurisdiction of Rome. Like, what do you mean the pretended jurisdiction of Rome? Okay, well, you know. Then they said under a pretended act of parliament. They said these people, Jesuits, are credited for turning the books of the law and proceedings of the court of justice into English. Right. So they rewrote all the stuff in favor of them and not in favor of the people. Right. We get that. All right. So we got these people right here, King George the First, King George the Second. Okay, well, because I didn't know they were German, I didn't pay attention to this guy right here, King George the Third. Right, King George the Third is the guy everybody talks about. They put him in plays and Hamilton and all types of stuff. Yeah, King George the Third, yada yada yada. Okay, well, King George the Third is the Prince of Germany during his lifetime, because I didn't know that. So he's the King of England, just like these guys are the King of England and the King of Germany. Okay, well, King George III was born in England or London, which is, I know it's in England, but so King George III is half German. King George III, y'all, people don't know this. King George III married a black woman called Charlotte. Charlotte, the city of Charlotte in North Carolina, is named after King George III's wife. In the back of my head, I knew it, but I never knew it. Like, I was like, oh yeah, some guy named King George III. I didn't know that was the King George III, because, you know, they rename each other all the time. And so this dude's half German. And I'm getting ahead of myself, but you get to the Declaration of Independence, the war, the Revolutionary War. They actually call it, I don't have it on the screen. It's called the War of Independence. They didn't call it a Revolutionary War. People want you to believe that it was a civil war. No. It was I don't know how to do the camera thing. It was a war of independence. The War of Independence. So I seen this recently. People on the internet saying, oh, well, the Revolutionary War, some dude, I guess, came out with a documentary or something on it. And they said, oh, well, it was really a civil war, as though these people wanted to continue living under no. And then they just let them go. No. They wanted to be free. See, this is what happens when you live in the hood. This is going to be an amazing live stream. All right, so I'm getting ahead of myself. Okay, so King George III is half German. I'm sure he speaks German, but that's irrelevant. So King George III is getting rumblings from these people who have taken over Parliament. And they're getting in King George III's ear and saying, hey, these guys in the colonies, they think they don't have to obey laws. They think they don't have to pay no tax. We wrote they owe us, so they owe you, King George III, some money. They said, oh, well, these people, they're profiting off of cotton and slavery and hemp and all of these things, and we've been writing saying that they owe us magically, without due process of law, without all of these things, without the consent of the people, and these boys ain't been paying up. Yeah, these colonies, they're rebellious. They don't obey the law. They think they're above the law. How many times y'all have heard that? Oh, you think you don't have to obey laws just because they write it, right? That they're the will of the legislature. You look up the definition of a statute, it is the will of the legislator. England has legislative sovereignty because of King George the First and King George the Second. They say, okay, cool, cool, cool. Let time go by. All right, King George the Third is on the scene. They say, hey, these boys in the colonies act like they don't know how to follow directions out here. When you, King George the Third, write something, then they're not obeying it. So King George says, okay, I guess I got to do something about it. And so he starts showing up. You start pulling up, showing up with the dogs, and they are getting to it. And so yeah, I mean, these are the rumblings that is taking place leading up to this pivotal event. And they say, okay, well, King George III is gonna start sending them boys out, sending the goons out. And let me see here. Trying to see some comments. Oh, they don't let me see them. Okay, blessings, Merry Christmas. Yeah, we're not putting that on there right now. There they go. There's gonna be some other fireworks in a second. And so King George III starts sending them goons out. So hey, you guys got to pay. You know what I'm saying? So they get the tea parties, they get all the Stamp Act and all of these legislative acts that these colonies are magically not obeying because they magically wrote the rules. And just because we wrote it, you have to pay it. I don't want to get in too much trouble, but that's what it say. That's what all this is about. These boys didn't care. This one, he half English, half German, so he kind of care, but not enough. He's still about that money too. He said, "Oh, they not paying? Oh yeah, you got to send them dogs out. Go ahead and send them." Right. So this is the rumblings of what will eventually lead to 1776. All right. Now, in the midst of all of that, you have this thing called the Quebec Act. The Quebec Act is Canada, right? So we got time going by. They're beefing with each other over all this stuff. And then you get to this thing called the Quebec Act. Well, in Canada, actually, I have this. This is perfect. I'm going to actually read it to you. I had it. There you go. Boom. All right. So in 1774, as far as England is concerned, England sends the military to Canada because Canada was an English territory. I don't know nothing about Canada, so some Canadians probably mad as crap at me. I don't know nothing about Canada. I believe they're under French control. I don't know how that works, but I don't care nothing about Canada. Sorry, Canada. But in 1774, they were under English control. And as a result of being under English control, they had access to the common law of England. Well, until these boys gave up legislative sovereignty and sent, remember, I just read it to you. The Jesuits, born under the king's dominion, under the pretended jurisdiction of Rome. This is in the 1730s. And pretended act of parliament, meaning fake laws. That's pretended is a legal term. It means, I don't have time to get into it, but it means fake. I mean, you know what pretended means, but it means fake laws. But they got different words for it now. They say under the color of law, all of these things. They act like it's law. It's not law because it wasn't under righteous authority, or not righteous, but delegated authority, right? So remember, these two, after these two gave up, it was never a lawful act, but that's another topic. But they say, okay, well, these Jesuits born in the king's dominion under the pretended jurisdiction of Rome and under a pretended act of parliament for turning the books of the law and the proceedings of the courts of justice into English was declared to be in force. And then they got all these statutes and stuff like that. Okay, so I'm just going to talk plain. These people were Roman Catholics. Okay, these Jesuits were Roman Catholics. Okay, so up in whatever was happening in Canada, this Quebec Act abolished English laws. And just so you know, I'm not just making stuff up. All of this is in the Declaration of Independence. But the Quebec Act got rid of English laws. So it took away their access to the common law of England. Okay. Which is what these English people at the time would have considered really precious. In fact, it was so precious. I'm about to read to you a response to the Quebec Act in the colonies. Somebody said, when did it go from the common law to maritime? Well, all of this is in 1066. It went from in the year 1066. It went from, because the common law is defined as the unwritten laws of England. Well, the unwritten laws of England, I don't know if you've been here at the beginning of the live, starts at 510 BC and goes until William the Conqueror. So William the Conqueror is from Normandy French. So he would have introduced the root of admiralty is just international law. And I'll make a whole video on that another day. But when did it go from common law to maritime law? According to history, in 1066 with William the Conqueror. William the Conqueror wouldn't have been considered English, and under the Anglo-Saxon people, he wouldn't have been considered Anglo-Saxon. It was a complete regime change because the last king of the Anglo-Saxon people was William the Confessor. He didn't have any kids, and his wife, they both vowed not to have any kids. They were devout Christians. And then when I say devout Christian, I don't mean Roman Catholic. And so William the Conqueror, all of these kings, even today, King Charles, they all trace their history to William the Conqueror, and they don't go back further than that. Okay, so this is very important. All right, so in 1774, what they call the American Continental Congress was written on the 5th day of September, 1774. They said that the inhabitants of the English colonies in North America, by the immutable laws of nature, the principles of the 8th of the English Constitution, it's in ancient English, I can't read this stuff, by the immutable laws of nature and the principles of the English Constitution, have the following rights. So they're preparing. They said, yeah, we're not with this. All right. They said they are entitled to life, liberty, and property, and they have never ceded to any sovereign power whatever a right to dispose of either without their consent. So they said we have we are entitled to life, liberty, and property, and we have never submitted to or ceded, given that to a sovereign power, the right to dispose of either without their consent. They said our ancestors who first settled in these colonies, 1607, were at the time of their immigration from the mother country entitled to all the rights, liberties, and immunities of free and natural born, what they called then subjects, within the realm of England. They said that the respective colonies are entitled to the common law of England, and more especially to the great and inestimable privilege of being tried by their peers of the vicinage according to the course of that law. What law? The common law of England. Because what we went over the timeline. When did a trial by jury start in ancient England? The year 1050. 16 years before William the Conqueror came on the scene. And they said they got that from the 12 apostles or the 12 patriarchs. They said the respective colonies are entitled to the trial by jury according to the course of that law. They said they are entitled to the benefit of such of the English statutes as existed at the time of their colonization. So when I cited earlier, the Supreme Court of Missouri, I didn't cite it, but when I said the Supreme Court of Missouri said that their law is the common law of England according to the time of King James IV. Okay, where they're talking about this period of Virginia and England, because in the colonies they said at the time of their immigration and colonization, right? They said they're entitled to the benefit of such English statutes that existed at the time of their colonization, yada, yada, yada. Okay, now they talk about this Quebec Act in the same thing. They said, so the same way the Declaration of Independence, and I'm going to get into it, is a list of complaints against King George III. Okay, well, they're practicing this. This is the first draft. Okay. And then they clean it up by the time they get to the Declaration of Independence. They say you can't put all that. The whole world will come after us if you put all that in there. So let's just fight one country at a time. Okay. So in the first draft, they said, and this is in 1774, they said, as a list of complaints, for establishing the Roman Catholic religion in the province of Quebec, abolishing the equitable system of English laws. They said, by the assistance of I can't read this. This is ancient English. So they say, by the assistance of whose blood and treasure the said country was conquered from France. Okay. They said, in another complaint, the act of parliament. So who did this? That legislator. Well, them boys are a problem, ain't they? They said the act of parliament establishing the Roman Catholic religion and the French laws in that extensive country now called Quebec is dangerous. Let me read it right. They said the act of parliament establishing the Roman Catholic religion and the French laws in that extensive country now called Quebec is dangerous in an extreme degree to the Protestant religion and to the civil rights and liberties of all America. Therefore, as men and Protestant Christians, we are indispensably obliged to take all proper measures for our security. They said, admit that the ministry by the powers of Britain and the aid of our Roman Catholic neighbors should be able to carry the point of taxation and reduce us to a state of perfect humiliation and slavery. They say it again. They say it one time, two times, three times, four times. The what's that song from Tupac? Diss and Biggie. Yeah, this is that. This is that song. They said, admit that the ministry by the powers of Britain and the aid of our Roman Catholic neighbors should be able to carry the point of taxation and reduce us to a state of perfect humiliation and slavery. They said the Roman Catholic religion is established, and the people there are deprived of the right to an inestimable trial by jury and English laws in the civil cases. They said the people there are deprived of the right to an assembly, trial by jury, and English laws in civil cases are abolished. And the English laws in civil cases are abolished. And instead thereof, the French laws have been established in direct violation of His Majesty's promise by his royal proclamation, under the faith of which many English subjects settled in that province. They said they moved there because we would be able to keep English laws. No, this is in 1774. This is a response to the Quebec Act in Canada. So the Quebec Act abolished English laws. That's why, boy, they shooting it up out there, ain't they? So this Quebec Act took away English laws. It took away a trial by jury, and it made them subject to what they call French laws. But they keep saying the Roman Catholic Church is doing this. Why? Because because France and the influence of France is subjected to the will of the Roman Catholic Church. Okay, so this is very important. Somebody said, so Canada was being taxed by England. Well, Canada was, well, not all of Canada is Canada today. I don't know nothing about Canada, but Quebec would have been different at the time than the rest of Canada, to my knowledge. So that part of what they now call Quebec, or Quebec, would have been under English territory. Would have been an English territory, and the people of England migrated there because they would have been able to keep their English laws. And so when the legislative will got given over to Parliament, okay, well, they start writing whatever. They say, yeah, we're not doing this common law stuff no more. No more tribal juries. We're not doing none of that. They said, we getting rid of all that, cut all that out. We're going to establish this Roman civil law system, or the Roman Catholic Church, or Roman Catholic religion. And as a result, Quebec today looks nothing like it was an English territory, right? Okay, so that was in 1774. So they said this Roman Catholic religion is established. The people are deprived of the right to the assemblies, trial by jury, English laws and civil cases are abolished. Instead, the French laws have been established. They said the French laws are the result of the Roman Catholic Church. So they said 4 times that I got screenshots of. They said the Roman Catholic religion, an act of Parliament establishing the Roman Catholic religion. Why is England establishing a Roman Catholic religion? Because these boys called the Jesuits showed up and took over the legislative branch of England at that time. And they were responsible over the books of the law, the proceedings of the courts of justice, and they declared what they wanted to be enforced. Okay, well, guess where they came from? They came from the Roman Catholic religion. They said the people are deprived, yada, yada, yada. Okay, so that's 1774. Remember, they started beefing here. King George III was sending them dogs, sending them boys out. All right, they said, yeah, we need some of that bread y'all making over there. Oh, y'all got slaves too? Oh, yeah, I'm going to need some of that. Need some of that. Right? And so, okay, we get to 1775. Oh, hold on. Yeah, they don't like the truth. They want you to authenticate and do all type of foolishness. All right, so you get to 1775, and my boy TJ show up on the scene. My boy TJ nasty with it now. He don't come to play. That boy spoke 4 languages by the time he was 9. Okay, he knew French, he knew English, he knew Italian, and he knew Latin. He said, yo, I got this. Let me take it from here. All right. So Thomas Jefferson writes the second draft called The Cause and Necessities for Taking Up Arms. He said, yeah, let me grab the mic real quick. All right. So in The Cause and Necessities for Taking Up Arms, he says that statutes have been passed for extending the jurisdiction of the courts of admiralty beyond their ancient limits, for depriving us. They keep saying that. They say this thing, what they say in 1774, they said the respective colonies are entitled to the common law of England, and more especially to the great and inestimable privilege of being tried by their peers of the vicinage according to the course of the common law. Okay, so that was very important to them. More than the rest of the common law, they said, no. If you're going to do anything, you're going to give us our trial by jury. Because that's where the people get to decide, okay? That's the only thing that protects us from the government in a legislative, in a court proceeding, is a trial by jury. That's how serious they were about it. So Thomas Jefferson gets up on July 6, 1775, and he says statutes have been passed for extending the jurisdiction of the courts of admiralty and vice admiralty beyond their ancient limits, and for depriving us of the accustomed and inestimable privilege of a trial by jury. Somebody put trial by jury in the comment section. In cases affecting our life and our property. So in 1774, they say, okay, well, this thing called the Roman Catholic religion is creeping into the colonies. They probably already there in 1774. They were already there in 1714 in England. And they start writing saying, oh, you magically owe us. You magically owe us. You magically owe. Oh, you got to do this because it's the law. We're not a, what they say, we're not a law. We're not a country of men. We're a country of law. So that means whatever we write, that's what you got to do. Right. And so 1774, they say, all right, well, the people who are doing this are called the Roman Catholic religion. They call it French laws, but we know who France is under. They're under the Roman Catholic religion. Look at France today. They look rough, boy. And so they said our ancestors were entitled to these English liberties, and they took them away from them in Canada. So y'all don't know how you read that Quebec Act, they talk about the Ohio River. The Ohio River goes right into Ohio. Goes right into what we now know to be Ohio, Michigan. I don't know those other states that are right there. Sorry, Northeast. But they said that Ohio River, that whatever they're doing right there on the other side of that Ohio River is creeping right into the colonies. Because people don't realize this. Go look at a map of the original 13 states or the original 13 colonies and the size of those colonies. Like people think, for instance, New York. Okay, well, New York went all the way, to my knowledge, to the Ohio River. So that when they say, okay, this Quebec Act thing is for real, this thing is nasty, because if they start creeping into our territory under the name of England, but they're enforcing foreign laws, okay, well, that's a problem for us. So we got to do something. We don't have a choice. Otherwise, that's it. And so you go look at the map of this Ohio River stuff. Okay, well, they talk about coming right on in with this thing. It said 4 times. Roman Catholic religion, Roman Catholic religion, abolishing a system of English laws, the Roman Catholic religion. Therefore, men and Protestant Christians are indispensably obliged to take all proper measures for our security. They say it again. By the powers of Britain and in aid of the Roman Catholic neighbors, that they should carry us to the point of taxation and reduce us to the state of perfect humiliation and slavery. Okay, this Roman Catholic religion is established, and they've deprived our Canadian brothers of the right to assembly, a trial by jury, and the English laws in civil cases. Hey, them boys letting them out. Okay, so that's 1774. 1775, Thomas Jefferson grabs the mic and he says, okay, yeah, this Roman Catholic thing is called admiralty. They said it's called the courts of admiralty, going beyond their ancient limits. And it is depriving us of the accustomed and inestimable privilege of a trial by jury, okay? Affecting cases involving our life and our property, okay? Then you get to 1776, all right? 1776, Declaration of Independence. They say, all right, you gotta clean this up. We can't fight the whole world. We can't afford to fight the whole world. We can only afford to fight, which they couldn't do it either. That's another topic for another day. But they said, all right, well, you got to clean this up. We can only fight England and maybe a little bit of France. Okay. And so, I forgot this too, because King George III is half German and he's the Prince of Germany. He They said the people in England wouldn't fight the colonies. And so he had to team, they make it seem like he had to team up with this random country called Germany, and they happen to have mercenaries there. That's why I stress this point of these guys were German. And this dude is half German. He was born in England, but his dad was literally German. This dude is half German, and they make it seem like, oh well, there were some random mercenaries that King George called upon to fight the colonies. No, they're literally under his command. They do whatever you tell them. They said, yeah, go to the colonies, handle business. And they make it seem like, oh, this random group of mercenaries, they couldn't find nobody but this random. No, King George knew exactly who they were. That was his family. He sent them boys out. All right. And so you get to 1776, and you get the Declaration of Independence and the official War of Independence. It is not a civil war. They said, we don't want to be a part anymore. Okay. So now we're going to go over the Declaration of Independence. Does that make sense, though? You get this timeline. You got Virginia coming on the scene, corporation, King James. You got King George I, King George II, who are completely German, don't care nothing about the colonies. They gave legislative authority over to these random people. Well, what he would think would be, okay, well, there's England. They're writing laws for England. Cool, whatever. Okay, no. These people called the Jesuits showed up, took over Parliament, took over the legislative will under fake pretended acts. They said, oh, yeah, we passed a law that allowed these. Yeah, they're going to help us clean everything up. No. And then by the time you get to King George III, well, he's half German. He still cares about Germany. He's still got German connections. He's the Prince of Germany. And so these legislators come and get in his ear and say, hey, these boys, they think they don't have to pay no taxes out here. They think they're above laws. They think they don't have to obey law. These sovereign citizens out here think they don't have to give us the fruits of their labor. And so we need you to send them boys out and go and start collecting and taking property and making sure that you, King George III, get what you're owed. And so this is the leading points up into the Declaration of Independence and the War of Independence. Okay. All right, let's get into it. I thought there was something else I was going to say, but yeah, that's it. Let's go to the Declaration of Independence. All right, so the Declaration of Independence is written into three parts. The first part is reasons why anyone would break off from their country. All right. So obviously it says when in the course of human events. So it says the unanimous declaration of 13 United States of America. That would have been the first time that phrase would have been used. Oh, somebody took some money from me. Oh, they gave some money back. All right. The 13 unanimous declaration of the 13 United States of America. They say when in the course of human events, it becomes necessary for one to dissolve political bands which have connected them with one another and to assume among the powers of the earth. They said nobody's coming to help us. So we got to go to the only one who might be able to help us. So they said assume among the powers of the earth that separate and equal station to which the laws of nature and the nature's God entitle them. So they said this is what anybody would do in this situation. We want to let you know this is why we're doing it, but this is reasons why anybody would do it. That we hold these truths to be self-evident, that all men are created equal, and that they are endowed by their creator with certain unalienable rights, that among these are life, liberty, and the pursuit of happiness. And they tell you that to secure these rights, governments are instituted among men. So they tell you, what is the purpose of government? To secure rights. That is their job, to secure rights. They said that to secure these rights, governments are instituted among men deriving their just powers from the consent of the governed. And they say that whenever any form of government, like people, I don't say this with any shame or any judgment, but we think that, well, the Declaration of Independence was the first time they ever would No. This is the third draft. They're like, all right, you got to clean it up one more time for us. Right? They tell you, okay, well, this thing didn't magically start on 1776, right? They said technically it started in the 1700s. I mean, I'm sure you can study any nation, any country, and they're going to have beef between the people and governments. They said there won't be a perfect government until Christ comes back. But until then, we got issues here and we need to solve them. All right. And so they say, hey, this ain't the first time we're doing this. This ain't the first time we've complained about this. This ain't the first time this ain't the magical, okay, well, we'll just do it on July. No. We technically, they said they were dropping bodies in 1774. So they said, okay, well, now we gotta make it official. So they said that to secure these rights, governments are instituted among men deriving their just powers from the consent of the governed. That whenever any form of government becomes destructive of these ends, what destruction? Taking away people's rights. It is the right of the people to alter or to abolish it. That's what the Supreme Court of Texas and the Constitution of Texas says. They said in the Texas Constitution, it says that the people have the absolute right to abolish or alter their government. Just like they did in the Declaration of Independence. They said whenever any form of government becomes destructive of these ends, it is the right of the people to alter or to abolish it and to institute new government, laying its foundations on such principles and organizing its powers in such form as them shall seem most likely to affect their safety and happiness. All right, so that's what the first thing of the first part of the Declaration of Independence is about. These are reasons why anybody would separate from their government. I tell people all the time, well, the real law of the land is the common law of England. And people say, oh, well, I knew we were still under Britain. I'm like, no, you're ignorant. You don't know what you're talking about. Why would they, after they said, hey, well, this is the reason we're separating, would still want the laws? Well, because the government wasn't obeying the laws. There was nothing wrong to them with the common law of England. They said that's the thing we wanted. That's the thing they're taking away. That's the thing they got rid of in Canada. Okay, and if we don't put up a fight, they're going to do it here. And so they said this is reasons why anybody would do this, because they're taking away our rights and they're not obeying the law, right? And I want to stress this point. They did all this. Remember, I went over this at the beginning of the live, but they had a whole reality, a whole history where under a monarchy, under the common law of England, they were, obviously they had conflicts. No part of history is perfect, but again, they were happy with their laws. They said, yeah, we want this trial by jury thing. Yeah, we don't want some random dude we don't know in a black robe just taking away people's property and putting people in prison where there's no injured party. Yeah, we don't like that. Nobody would like that. Right? And so they said, like, hey, there's a reason why when this random black guy gets on YouTube and TikTok and says, hey, this common law of England thing, you probably want to pay attention to it, because if they had this supposedly revolutionary war and you get on the other side of this revolutionary war and they're saying, oh, well, the real law is actually the common law of England. Well, why would that be significant to them? Okay, because that was the thing they believed best protected their rights. So when some random black on the internet says, hey, the common law of England may be the real law, you might want to look into that. And then some people say, oh, well, there's no way it could be. We broke off from England. Well, you don't know why they broke off from England, or you're obfuscating the truth and not telling the real reason why they broke off from England. They tell you in 1774 why they broke off from England, because Rome invaded the English Parliament and started writing fake laws. They called it pretended legislation. They say it. Under the pretended acts of Rome, these Jesuits took over the Parliament and took over the books of the law and the proceedings of the court under the pretended jurisdiction of Rome. Well, they don't have no real jurisdiction in England. Right? They've never been entitled to England. And under pretended acts of Parliament. Right? So these are all fake acts. People tell me all the time, yeah, well, in 1913 and 1933, the executive order took away all the gold. So that means they magically have to pay bills that you should have never had in the beginning. I'm like, what? Okay, well, there's no such thing as an executive order in the Constitution. So it's all fake pretended legislation. It's not real. It's not authorized by law, right? So you get to the second part of the Declaration of Independence. The second part of the Declaration of Independence is a list of grievances against King George III or against the British government. Okay. The first thing they tell you. So let me see, yada, yada, yada. The right to alter, abolish, and institute new government, laying its foundations on such principles, yada, yada, yada. Safety, happiness, prudence. Yeah. He real nice with it. All right, here we go. It says the history of the present king of Great Britain is a history of repeated injuries and usurpations, all having in direct object the establishment of an absolute tyranny over these states. He says, and I need to say this too, a declaration is a legal term. This is a legal document to them. To these people, they said, to prove these facts or to prove this, let these facts be submitted to a candid world. Okay, well, when you go in court and somebody makes a complaint against you, well, they have to do that. They have to prove the facts of the case of what actually happened in a what they call it, not a complaint, I can't think of the word, but they make a complaint against you. All right, well, that's why they have to have an injured party. That's what they say. What they say, repeated injuries and usurpations. Okay, well, that's why in today you have to have an injured party. These are some of the inklings of English law. Okay, you can't go before the court of the world and appeal to the supreme judge of the world, which are all statements in the Declaration of Independence, and not have an injured party who has what they say given them a history of repeated injuries, and then they write those injuries down and submit them as the reason why they are administering justice according to the laws of nature and of nature's God that entitle them. Okay, so this is a legal document. They said, and the proof of that is they say to prove this, let these facts be submitted. So when you get somebody who makes a complaint, you have to verify all those facts to see if they have been alleged, that's the word I was looking for, to be true. Okay. It says that King George has refused his assent to laws. The first thing they say is he don't obey the law. They told you in 1774. Okay, well, they getting rid of laws in other places, and he ain't even obeying them in here. They said our problem was not with the law. See, these Parliament guys, these Jesuits, I need to write that down. Jesuits went to King George III and said, oh, these people think they don't have to obey laws. They said, no, we have a law. It's called due process. It's called you're not allowed to take our property and our stuff and put us in prison without a jury of our peers. They said that's the law. That's from the Magna Carta. They said that was before the Magna Carta. This is just a backdrop for me. Sorry. And I don't know how to move it because if I move it a certain way, the light from the monitor is going to get on the board. So sorry. But they said, yeah, these boys think they don't have to obey laws. They think they above all this stuff. They think they can work and not give us any of it. They said, no. This guy is not obeying the law because in order for you to take our stuff, you have to submit this to the community. The people are the ones that are in charge here in these colonies. We don't work for Parliament. And clearly Parliament don't work for us. And because of that, King George has refused his assent to laws, the most wholesome and necessary for the public good. They said, let me see, I'm not going to read all these, but it says again, he's refused to pass other laws. They say it 3 times. Let me see. There you go. He has obstructed the administration of justice by refusing his assent to laws establishing judiciary powers. He has made the judges dependent on his will alone for the tenure of their offices and the amount and payment of their salaries. He has erected a multitude of new offices and sent hither swarms of officers to harass our people and eat out our substance. Sound familiar? What else? He has kept among us in times of peace standing armies without the consent of our legislators. They said they was writing laws, but it wasn't with the consent of the legislator. Who was the real legislator? Not these Jesuit guys that showed up and took over. They said we didn't have a problem with writing statutes. They said we had a problem with foreigners writing our statutes. Uh-oh. He has kept among yada yada yada. The consent of our legislators, he has effected to render the military independent of and superior to the civil power. Here we go. My favorite sentence in the whole Declaration of Independence. I'm going to spend the next 3 hours on this one sentence. I'm just kidding. It says that King George has combined with others to subject us to a jurisdiction foreign to our Constitution. Remember, 1774, they name names. They're not putting up with it. They said the Roman Catholic Church did this. In 1775, he cleans it up a little bit and says, oh, okay, this thing called admiralty is the thing that's passing these statutes. And then when you get to 1776, he says, oh, okay, well, King George has combined with others to subject us to a jurisdiction that's foreign to our Constitution. What was their Constitution? The Magna Carta, that says you cannot bring people into court. First of all, the Magna Carta is nasty. I'm going to do a whole thing about the Magna Carta. In the Magna Carta, it says that the sheriff, the bailiff, whoever is an officer or agent of the king is not allowed to just go after people and bring them into the courts of common pleas or courts of the king's bench, whatever it said. So that they said you were not allowed to just create court cases where there is no injured party. And then obviously you got the due process clause where they say, hey, you're not allowed to take our property or put us in prison unless it is by the judgment of our peers. I'm here every day, so I live stream almost every day. Unless I'm out of town, I live stream every day. So I'm knocking it out. A lot of these videos, I just started making videos again, but I went over the first part of the common law, the timeline of the common law. This is part 3 technically. So I went over the first part of the common law, which was the year 510 BC up until 1066. Then we went from 1066 to what? To the 1700s. We talked about William Blackstone. And now I'm just going over another timeline, the 1600s, just getting deep into the 1700s to understand how did we get to the Declaration of Independence. And then I'm probably going to make a couple videos on the Constitution. And then I'm just going to go head on into each major point of the common law of England. So I'll be here every night, and Lord willing, I'll be here every night until I run out of money and I got to go back to work. They said, let's drain his bank accounts tonight. So they said, King George has combined with others. Okay, well, in 1774, they tell us who those others were. They called it the Roman Catholic religion. Well, really, they told you in the 1730s, which is the same people, but they call these guys the Jesuits. And then you got these people in 1774 called the Roman Catholic religion. He said, okay, well, You got these people called the Admiralty. Yeah, the courts of Admiralty extending beyond their ancient limits. And then in the Declaration of Independence, it says, well, King George is actually combined with others. So now they're others. He got to clean it up. They cannot fight everybody at this point. We don't realize this, but that's the United Nations before there's such thing as a United Nations. If Thomas Jefferson runs his mouth inappropriately, okay, all of it gets wiped out way too soon. Okay. So he says King George is combined with others to subject us to a jurisdiction foreign to our Constitution, the Magna Carta, and unacknowledged by our laws, the common law of England. And there he goes again. He says it 3 times so far. He says that King George has refused his assent to laws, the wholesome and necessary for public good. He has, where does it say it again? Yada, yada, yada. It's somewhere in there. He says it a second time. He's refused his assent to laws. Then he says it a third time. He says, subjected us to a jurisdiction foreign to our Constitution, unacknowledged by our laws, giving his assent to their acts, somebody else's acts of pretended legislation, say fake laws. Quartering large body of troops among us for protecting them with a fake trial. Yeah, how many times you seen a police officer get away with abusing people? They send them on vacation. They say, you get paid with leave. You get leave with pay. That's what they call it. Leave with pay. Yeah, he's been suspended. Leave with pay. He on vacation. He's going to the Bahamas. he just put his knee on the neck for 15 minutes on national television. Yeah, he's going to the Bahamas for the weekend. For the next 3 weeks, actually, until we dismiss the case. For protecting them by a fake trial from punishments of any murders which they may commit on the inhabitants of these states. This stuff is in the Declaration of Independence, y'all. We complain of these things every day. For cutting off our trade with all parts of the world, imposing taxes on us without our consent. We know about that one. Depriving us, in many cases, of the benefits of a trial by jury. There you go. Say it again. They said for transporting us beyond seas to be tried for pretended offenses. They say it twice. He's given his assent to their acts of pretended legislation. He says for transporting us beyond seas for pretended offenses. And if I had time, I would teach you they didn't go nowhere. Remember, they went from having a trial by jury where the jury were the judges and the judges were the people in your neighborhood or vicinage, what they said in 1774. And now they're being transported beyond seas. Okay, well, that's an admiralty term, meaning that now instead of going before the people, you just go before a guy in a black robe. They just took him across the street. And going across the street and the people not being the judges was going beyond seas. So they didn't send them back to England. They didn't do it all. They would have killed them if that was the case. They probably did. If they really had to go back to England, yeah, we're just getting rid of this guy. So they just took him across the street and brought a guy in a black robe and said, oh, I'm the judge now. Don't worry, buddy. And then just took away his life and property. Right? So they say it. The first sentence, okay, they're depriving us of a trial by jury. The next sentence, oh, well, now they're taking us beyond. They just went across the street. So instead of the courts of common pleas, see, when you start studying this common law thing, you'll learn all that. They got 2 types of courts. They got the courts of common pleas. That would have been the common law courts where you had an injured party. You had a grand jury. You had the petite jury. The petite jury would say, okay, you're guilty. They prescribed the offense. The grand jury would actually create the case, and they would only call the sheriff to summon the jury from the neighborhood or help investigate. The grand jury would be what we now know to be, they said the FBI would be based off of the grand jury. The grand jury would have been the people, the elders of the community. They would go investigate and see if this was a real case that needed to be tried. They said, okay, well, they're depriving us of all this now. They took one dude across the street, and instead of bringing him before the people, they're bringing him before a stranger. And I got plenty of cases in law books that say, okay, well, when they went across the street to try this dude, okay, well, they They're taking away his property. They're taking away his life. They're doing everything. They're establishing all these commercial entities, and it's all international. They said they would beef so bad that if they gave them a jury, okay, that jury would throw that case out. They used to beef real hard in the 1770s. It was, they said, one book I got say, okay, well, the jury would throw the case out and the king's revenue would be impaired. They would bring a revenue case, which is an admiralty case, before the people because they called it a crime. Same supposed to happen here. If they call it a crime, it's supposed to be a trial by jury. Well, in that trial by jury over a revenue issue, well, the people knew. They're like, yeah, we're not trying this. So they would throw it out and then they would just go shoot it out after the court proceeding because they weren't with it. Like they were not playing. So if you got brought before the jury over a revenue case, they said, yeah, we're not allowing this to go through. So if the grand jury don't kick it out, then by the time it get to us, we're not going to hear it. We're going to pronounce the dude innocent. That's how it's supposed to be today, but that's another story for another day. All right. So they say transporting us beyond seas to be tried for pretended offenses, admiralty. And then they talk about this Quebec Act in the Declaration of Independence. They say for abolishing the free system of English laws in a neighboring province, establishing therein an arbitrary government and enlarging its boundaries so as to render it at once an example and fit instrument for introducing the same absolute rule into these colonies. I told y'all that thing was on the Ohio River. Go look at, I think it was the Ohio River. I'm pretty sure it was the Ohio River. The Ohio River went into, I think it ultimately connected to the Mississippi. I could be wrong, but I've been on the Ohio River in Ohio and West Virginia in the oil fields up there. But I believe before it was Ohio, I believe it was a territory of New York, and that would have taken it to the Canadian USA line. But that's another story. But just know, in 1774, they're talking directly about this Quebec Act, and they said it's the Roman Catholic religion in the province of Quebec, abolishing the system of English laws. Okay, in the Declaration of Independence, he had to clean it up and say, for abolishing the free system of English laws in a neighboring province, establishing there an arbitrary government. They said that thing wasn't by law. That thing wasn't by the will of the king. That was by the will of the legislator. That ain't authorized by law under English law. So they said that's the Roman Catholic Church right there. So if I ask you, well, who were they really fighting during the Revolutionary War, during the War of Independence? Who were they really fighting? Because I told you, King George III said he had to contract these people called the Hessians. They were German mercenaries because he was half German. Well, the people in England wouldn't fight their cousins in the colonies. So he had to team up. They said, and I could be wrong about this, but I'm pretty sure they said it was the Hessians, the Germans, and the Russians, and like a mixed group of these guys. But they're all working on behalf of the Roman Catholic religion. We already know who's writing the laws, so we know what the real war is about. I got another book. It's by Supreme Court Justice Joseph Story. He's got this thing called, he's dead. He's super dead. Justice Joseph Story wrote commentaries on the Constitution of the United States. It's in 3 books. The first book, he goes over the 13 colonies and how they got set up. And when he talks about New York and Massachusetts, I know this because when I read it, I was in New York and Massachusetts. He said that they used to pass laws in the colonies about these Jesuit priests. These Jesuit priests had gotten so bad that they had to execute them. That they said, especially I believe it was New York, they said it had gotten so bad that anybody who was a Jesuit or Popish priest got sent to prison. Any one of those guys who escaped prison were to be executed. That was the law. And then when you get to 1777, New York has a New York Constitution. They say in that Constitution, anybody who acknowledges the spiritual supremacy of the Pope, you getting dealt with. That's how serious it was. That any laws that were contrary to the common law of England, it was seen as direct opposition. So these people were abolishing the free system of English laws in a neighboring province. They're talking about the Roman Catholic Church. And enlarging its boundaries. They say it in 1774. This is direct quote. He just had to clean it up. And then he said, for taking away our charters, abolishing our what's our charters? The Magna Carta, abolishing our most valuable laws, and altering the fundamental forms of our government. He said this happened during this time period. He said suspending our own legislators. I'm trying to see anything else. Waging war against us. He has abdicated government here, declaring out of his protection, and then started waging when the government starts attacking the people, right? And then he says, Thomas Jefferson says, at this time, transporting large armies of foreign mercenaries to complete the works of death, desolation, and tyranny, already begun with circumstances of cruelty and perfidy scarcely parallel. I'm not going to read all. I can't read all that. You know what I mean. You need to read what happened to the signers of the Declaration of Independence. All of them had their houses burnt down, killed their kids, stabbed their wife, burnt down their stuff, stole everything. Because on the other side, it's considered an act of war. On the other side, they said we're being invaded from foreign mercenaries, right? So they say, so that's the second part of the Declaration of Independence. It's a list of grievances against the British government and King George III, okay? And then, yada, yada, yada. I'm trying to see if anything else. He has excited domestic insurrections among us. He has endeavored to bring on the inhabitants of our frontiers, the merciless savages whose known rule of warfare and undistinguished destruction of all ages, sexes, and conditions. Okay, yada, yada, yada. All right, it says, in every stage of these oppressions, we have petitioned for redress in the most humble terms. Our repeated petitions have been answered with only repeated injury. A prince, remember, he was the Prince of Germany at the time, whose character is thus marked by every act which may define a tyrant, is unfit to be the ruler of a free people. They said under a king, they were considered free as long as they had that common law. So they said, nor have we been wanting in attentions to our British brethren. We have warned them from time to time. How many times you heard that? How many times you seen a sovereign citizen video where these dudes are trying to fight for their rights? They're trying to argue with cops and say, hey, you're breaking the law. Hey, you're the one not obeying the law. I have a right to travel. I have a right to yeah, all this stuff. Yeah, all this is happening in 1776. They said, we have been giving attention to our British brethren. We have warned them, hey, the government's breaking the law. Hey, the government's breaking the law. Hey, the government's breaking the law. And time to time of attempts by their legislator to extend an unwarrantable jurisdiction over us. This stuff is not by the law. They said we don't have a problem with the law. They said the problem is they're not obeying the law. We have appealed to their native justice and magnanimity, yada, yada, yada. We must therefore acquiesce in the necessity which denounces our separation and hold them as we hold the rest of mankind. Enemies in war, baby. They say it's time to get to it. Time to get to it. They said, strap up, boys. Actually, I forgot about this. When I first started studying this years ago, I think it was Benjamin Franklin, which you can say what you want. I think he may have been a traitor too, but don't forget they had enemies they thought were friends and all type of stuff. So that None of these guys are my friend. Right? But they say Thomas Jefferson went to England and said, hey, we trying to work this thing out, and y'all not giving us no wiggle room. And King George III was like, oh, you don't understand. We're the mother country, and you guys are the subjects. You always will be our subjects. You're not obeying the law. You need to come on back, and yada yada yada. And Benjamin Franklin wrote the boys and said, "Yep, time to strap up." They act like they don't want to hear us, so and they got to it after that, and the rest is history. And I'm not going to go over this tonight, but I don't think we won the war, but that's another topic for another day. But they say, we therefore, the representatives of the United States of America and General Congress assembled, appealing to the supreme judge of the world. They said, we got no friends in this. The Roman Catholic religion has taken over 90% of the planet, of the known planet at the time. And they already done took over Canada. They said, that's it, boys. They say we got to go to the supreme judge of the world for this one. For the rectitude of our intentions, in the name of and by the authority of the good people of these colonies, solemnly publish and declare that these united colonies are and of right ought to be free and independent states, and they are absolved from all allegiance to the British crown, and that all political connection between them and the state of Great Britain is and ought to be totally dissolved, and that as free and independent states, they have full power to levy war, conclude peace, contract alliances, establish commerce, and do all other acts and things which independent states may of right do for the support of this declaration, with a firm reliance on the protection of divine providence. We mutually pledge our lives, or pledge each other our lives, our fortunes, and our sacred honor. And then you got the signers of the 13 colonies, and you go study the lives of them. They all ended, most of them ended in destruction. Most of them had their houses burnt down. They were fighting in all different types of winter. So they burn your house down. That's it. You can't build another house for another. It's like a good month to get a cabin up. You know what I mean? And so kids got killed, wife kidnapped, raped, all type of stuff. So this is the story or the history of what led up to the Declaration of Independence. What I want to last go over is the argument that the Declaration of Independence is not law. You will hear from attorneys. You will hear from primarily attorneys. They're primarily they're of that order that say, oh, well, the Declaration of Independence isn't binding law. Okay, well, the United States statutes at large is federal law. It is law for the federal government concerning federal things, the federal corporation, yada, yada, yada. Okay, well, every statute at large is considered federal law. The very first citation of the United States statutes at large, actually, I can pull it up right here. I have the United States statutes at large saved on my computer. So for those who don't know the hierarchy of federal law, you have the United States Constitution, you have the United States statutes at large, then you have the United States Code, you have the United States Code of Federal Regulations, you have Supreme Court cases, federal Supreme Court cases, federal circuit court cases, federal district court cases. So technically, as it relates to federal law, you have the United States Constitution and the United States statutes at large. The United States statutes at large is the official legislation of the federal government. So if you want to ask if something is law, if it's not in the United States statutes at large, they put things that are in the code that are not in the United States statutes at large. Okay, well, then it's not federal law, right? So the very first enactment of the United States statutes at large is the Declaration of Independence. So if you go to the statutes at large, it will be volume 1, page 1 of the United States statutes at large. And it says in Congress on July 4th, 1776. It is federal law. The United States, or the Declaration of Independence, is federal law. You go to page 4, page 5, maybe. No, that's right. Page 4 is the Articles of Confederation. You go to page, I believe, 9. So this is volume 1, page 4, volume 1, page 9, page 10. Is the United States Constitution. All of these things are federal law because it wasn't enacted in the United States statutes at large. Does that make sense? So whenever somebody tells you, oh, well, the Declaration of Independence isn't, well, is the United States statutes at large federal law? Yes or no? Okay, what was the first enactment into the United States statutes at large? It's the Declaration of Independence. So the reason I say that is because I can prove, and I'm going to hopefully try to prove it, there's not one accusation against King George III that is valid law in this country. Does that make sense? So we just went over a list of grievances against King George III and against the British government. And there's no way that would, after 1776, be valid law here. Does that make sense? So when they say, they got one where it says, okay, well, they get a trial by jury in civil cases. Okay, well, guess what? You get a trial by jury in civil cases in America because they don't get on the other side of this and say, oh, well, now we got rid of it. No, that's the law. That's what they wanted. They literally broke off from England or broke off from Great Britain because they weren't obeying the law. So they don't get on the other side of that and say, oh, well, we're just going to get completely rid of the common law of England. No, that is the law. Whatever was afforded to us by the common law of England, whatever protected our rights, primarily due process and a trial by jury, then that is the law. I'm trying to make sure. Oh, I got 11 minutes. Oh, I did it under 2 hours. Let's go. So there's not one citation against the British government that is valid as, oh, well, now it's law here. No, there's not one. So, yep, that's pretty much it. That's all I got. Any questions? Almost drunk from my microphone. Do y'all see that? There's not much. So you got 1607. They come in 1607. You got Virginia Company, King George IV. There's a bunch of queens in between that, but that I didn't find anything that significant. You got 1714, King George I, King George II. They didn't speak English. They were German. They did not care about England, but they were the king of England. They gave legislative sovereignty over to Parliament. These guys showed up. They had been there and took over the legislative will of England. And then by the time you get to King George III, they're in his ear saying, hey, these boys think they don't have to obey laws. They think they don't have to pay. They think they don't have to do this. They think they don't have to do that. They're making so much money. They got more land than us. They were haters. They were haters. And then you got the Quebec Act in 1774, where they took over Canada. Maybe not all of Canada. I don't know. I don't know nothing about Canada. No offense to Canada, but I don't know nothing about Canada. But they took over Quebec, whatever Quebec is. They took that over. And then in 1775, Thomas Jefferson takes over the mic. He says, yeah, these boys are extending the courts of admiralty beyond their ancient limits. I'm going to make a whole video about that when I go over I'm going to make a video over each type of case in the Constitution, and I'll put it on YouTube. This video will be on YouTube, probably in 2 parts, but it'll be on YouTube probably in the morning. So 1775, Cause and Necessities for Taking Up Arms by Thomas Jefferson. And then he's got to clean it up so he don't get taken over by the whole world. in 1776, Declaration of Independence, or the War of Independence. And then we went over the 3 articles, what the 3 articles of the Declaration of Independence is about. And then the Declaration of Independence is also, I forgot to say this, it is also in the United States Code. It is in the, they call it organic law, the organic law of the country. And it's at the beginning, the very first publication of the United States Code. They have the Declaration of Independence, they have the Articles of Confederation, and they have the United States Constitution before they start the code. And then the first enactment in the United States Statutes at Large, Volume 1, Page 1, is the Declaration of Independence. It is federal law. Even if they don't want to believe it's federal law, it's federal law. A declaration is a legal document. Yep, that's it. That's all I got. So, any questions? Any questions before I get up out of here? That's actually pretty good. 153. All right, I'm on YouTube, Constitution Academy. I'm on Patreon. If you want proof of everything that I'm saying, I got nothing but Supreme Court cases that affirm and prove all of this stuff. I got a million law books. Everything that I learn is primarily on the Patreon. So it's $5 a month. Just search, go to patreon.com, search Constitution Academy. It's $5 a month. All right. That's it. Merry Christmas.